how often do you get paid $40 to stand up and talk? Thanks so much, Mark, and thanks so much for everybody in the group who's been helping me out on the Thomas House thing. It means a lot to me, as I think most of you now know. I'm here to talk today about employment law. I put some flyers out. There's been some employment law changes you might be interested in. One of the things that I do, if you look at my flat fee schedule, which nobody else does, is I will basically put an entire employment program together for you. And it's cradle to grave, it's A to Z, and it starts with an application and it ends up with your last termination notice and final check. Why do you do that? Well, you know, I always tell people I make most of my money from litigation. And in the state of California, probably the riskiest and the most costly part of your business is those little folks you call your employees. Or, even more so, those people you don't want to call your employees, who you call independent contractors, and who are going to come back and cause you serious problems. So I try to exhort my fellow business folk, right, to get an employment program, which we call a due diligence regime, together, so you have a plan for dealing with these very expensive, very costly, very risky people. And I put it together in a package. It's a flat fee package, and essentially what I do is I'll do everything that needs to be done until you're satisfied, and here's the important part. Con, are you listening? Right? Until all the employees finally sign for the handbook, and they sign for the application, they sign the offer letters. You cannot believe how often I put together these programs, and then I call up later and I say, so did everybody sign? And they go, not yet. And I go, why not? And they go, I don't know, just haven't gotten around to it, don't want to bring it up, or we've been busy, or blah, blah, blah. That is absolute death. You want a really hard lesson? I'm doing a litigation right now. We've gone over $100,000 in attorney's fees and costs. And you know why we're doing this, ladies and gentlemen? Because the employer did not get the employee to sign the application, the offer letter, or the employee handbook. They had it all, had the name all typed, written out and everything, just didn't get the signature. So guess what? We're going to spend a year and a half or even 2 years in California Superior Court litigating. You don't need to do that. All you got to do is get them to sign. And it's even easier than that. If you don't have a plan now, right, all you need to do is get a plan, work through it with me, get them to sign, and you can avoid this unpleasantness. How many people here can afford to spend 100 to 200 grand on an employee litigation? See, nobody. I bet everybody in the room has an employment program, right? No, actually, more than half of you probably don't. And you see, that's where the disaster is waiting to happen. Because this is extremely costly litigation. And it is very, very hard to win. And believe it or not, the law is set up that even if the plaintiff, the employee, sues you and brings a frivolous claim, you have a very, very, very hard time of getting your attorney's fees back. So it is front-loaded, all in their favor. So all you can do is basically put a plan and a program in place that will deal with that. And what does the program start with? It starts with an application, right? You'd be surprised how many employers don't take applications. What is an application? An application is an opportunity to start communicating with the person who wants to work with you. You can find out what they know, what they've done, where they've been, all that sort of stuff. That's helpful, right? But here's another thing you probably haven't thought about. An application is also a form of protection for you because it can also be an agreement. And one of the things I insist on in all my applications is they sign, even if I don't get hired, right? If I want to bring a discrimination claim or some other type of claim against you, we're going to arbitrate it. How's that? That's just one form of protection that you could have, right? Not even hiring somebody. And then we go to the next part, when you have an offer letter. You know how many people in this room have trade secrets? I won't go into what a trade secret is, but you have trade secrets. And probably the most common trade secret is what you call your customer or your supplier list, right? And you know how many people hire employees, give them access to all of that, and then when the employee walks out the door, they take them with them? So every offer letter I put together has an agreement about trade secrets, which includes, very specifically, customer lists, supplier lists, right? And says, by the way, if we part ways someday in the future, you agree that those are trade secrets and you're not going to take those with you and you're not going to use them. Is that a good thing? Oh yeah. Why? Because I have a client right now who had a manager in one of the restaurants that had access to all those things, is walking out the door, going to start a new restaurant, and guess who is going with him? All of the customers, all of the suppliers. And of course, everybody shows up at my door and says, what can I do about that? Well, let's just say it's very difficult. If you have this regime in place, it becomes a lot simpler. And then we go to the employee handbook. How many people have employee handbooks? Right? Not everybody. An employee handbook is basically a playbook. It says this is how we're going to do things. One of the most important things in it, even if you don't pay attention to anything else, because a lot of employers don't, right, is that it has an arbitration agreement that says if we have a dispute later, we're going to arbitrate it. That's the saving grace. Even if you screw everything else up, having an arbitration agreement is going to help you. And then you have a disciplinary section of this regime that deals with when you have disputes while you're working with the employee. And everybody asks me, why do I have this? And it's one, a communication device. You can have communication back and forth, and it memorializes that communication, and it also protects you because it shows you're not a really nasty, arbitrary beast who's just doing mean things to people for no reason at all. And then there's the termination thing. We have a termination module which deals with what happens when they leave. Well, you want to memorialize that. You want to memorialize that you paid them all the stuff that they were owed. You want to memorialize that, yes, they're not going to take any trade secrets with them, and some other stuff. And then you part ways. Why do you do that? Probably 50% of the litigations that I have are wrongful termination. They include all kinds of allegations that they weren't paid their wages, that they were extorted into agreeing things that they never agreed to, and this is all basically he said, she said. So if you have all of this written down, you just pull this out and say, that's not really the truth, is it? Saves you a lot of heartache, especially if you have to go in front of the Labor Commission, right? Because the Labor Commission turns around and looks at it and says, that doesn't really jive with what you're saying. So this is very important stuff. And if you don't think that it's very, very expensive to deal with all this stuff, it really is. As I tell people, I make money off the litigation. I make a lot of money off the litigation, unfortunately. Right? All I'm saying is, for you guys, if you don't want me to make a lot of money, do this regime and basically have it in place so when something does come up, I'll give you an example. Probably once every 15 years, an employer will have a problem. That's not a lot, but that one could kill you. Right? And when you look at this plan that you have in place and all the problems that you can avoid in the meantime, it just makes sense. Questions? Protests? Yes, sir.
Not plenty, but if you put one of those things, can employees go back and say, well, this was beforehand. If we put these contracts in place effectively, can they go after you from previous moments?
That's a very vague question.
Retroactive, yeah. Can they go back and say, well, we didn't have this agreement before, so I'm going to go after him for the years before where he didn't have this? Once they sign an agreement, they agree that stuff before that, right, is governed by the agreement, right? Cool. And here's the cool part. The stuff going forward, definitely covered by the agreement. Yeah. So here's the deal. You want to get the agreement signed as soon as possible. Yeah. Ron?
2 minutes, but I will ask a question.
Sure, Ron.
Since I raised my hand.
Yeah.
Actually, not a question, but I have predominantly an independent contractor scenario as opposed to employee-employer relationship.
And Ron is well advised on that.
Yes, because the person who is doing all that for me is Mark, and I just want to say Mark's helping me out with a ton of different things, and I run everything by him, and it makes me feel good every single time I've got something going on that requires legal documents. I just send it over to Mark. So that's not really a question, but how do you deal with a growing independent agency and the government trying to clamp down on this employer versus independent contractor scenario?
I think, as I've discussed, I've discussed with a lot of people who do this, especially the sales commission independent contractor agreements. The best thing to do is to put in the clauses that I put in, right? Yeah. And basically, the golden ticket, right, is having separate commercial general liability insurance in place. And when you coordinate that with these agreements, right, it makes it very clear to all concerned that yes, these are two separate entities or people, right, that are doing things separately, right? Because nobody in their right mind who was an employee would buy insurance where they have their employer as an additional insured. It just doesn't compute. So if you do that, right, that's your golden ticket. If you don't, you might have problems, right? So essentially, when I put these agreements together, you'll see every agreement has that in it. And it has indemnity and harmless and all this other stuff that only people working at arm's length would do. And you see, that's very important, because all the other stuff is helpful, but stuff like that makes it very clear because it's right there in front of you. It's physical. It's something you can see, something you can really come to grips with. So that's really the best way to do it. Yes, sir?
Many questions. If an employee or independent contractor along with you, should you still have them sign something so that would cover you for the retroactive stuff?
I'm sorry?
If an employee or independent contractor along with you,
Yeah.
should you still protect yourself from the stuff for the time
Yeah.
that they weren't there?
I think what you're trying to get at, if I understand correctly, is can you basically get an agreement like when they're going away, right, and say,
Well, in this case, I've already left.
or they've already left. Yeah. That's not really a good idea. Here's the thing. Here's the thing. I have so many people call me up saying, I'm firing so-and-so. Can I make them sign a settlement agreement? No, it's the same thing. Or after they've walked out the door. By then, ladies and gentlemen, it's too late.
Yeah.
Right? It's too late. You want to do it while they're working for you or before they start working for you so that it's very clear from the beginning, because just think of it from a common sense standpoint. When somebody's walking out the door, they probably are not having all happy feelings with you anyway, right? And then you say, would you please sign this settlement agreement so you won't sue me? What do you think the chances are that that's going to be successful? And here's the final thing. How does that make you look? It makes you look cheap and petty and kind of overreaching. And you don't want to do that. That's why I think putting a program in place will probably be the best thing long term. Thank you very much, ladies and gentlemen.